Hello, and welcome to another U.S. Tech Workers podcast. Today is Wednesday, October 2nd, and I'm joined by a special guest who should be no stranger to our audience, John Miano. John is an attorney, an engineer, and an author. And today we're going to talk about what happened last Friday at the U.S. Federal Court of Appeals, Washington, D.C. circuit on a case that John has been battling with the federal authorities for the last few years on. John, welcome to the podcast.
Hey, thanks for having me, Kevin.
Well, great to have you here. So, John, last Friday, I had the pleasure of watching you in action as a champion for tech workers and the importance of your case, as I understand it. So last Friday, 3 justices in the U.S. District Court, Circuit Court of Appeals heard your oral arguments along with those of Department of Homeland Security and a special intervener who, as I understand it, was Immigration Voice.
That's correct.
Right. And basically, Department of Homeland Security had enacted a policy where they would rescind the H-4 visa program, the program that would allow about 100,000 spouses of H-1B workers, give them status to work here in the U.S. Now, tell me about...
Correction.
Okay, go ahead.
A little correction here is that the visa was created by Congress, but it doesn't allow work. Under the Obama administration, they started allowing certain spouses of H-1B workers, so these are the people on H-4 visas, to
Correct.
work as well, okay? And
that's why they call it the H-4 EAD.
Right. So that's what's being challenged in court, because DHS is claiming that it has unlimited authority to allow foreign workers into the job market through regulation. So what is happening now is big business isn't even bothering going to Congress. They're going to the agency, DHS, and saying, can you come up with a regulation to give us more tech workers? And then, all these guys working at the agencies are, usually at the end of their term of office for the president, and then they're, looking for their lobbying jobs afterwards. So they're only too happy to grant the request to big business.
Well, the way this plays out on the ground is, I know an example, a person in Pennsylvania who was the last of the Americans to be let go in her shop, all of them replaced by H-1B visa workers, and her boss, who had originally come to the country on an H-1B visa, she was replaced by his spouse, who was on an H-4. So that tells you what's going on, because it was interesting, John, when you opened up the hearing with, they heard arguments from you first. And it was really interesting because they beat you around pretty good, I thought, the 3 justices. Now, I thought that didn't bode well, but then the other guys got their time in the slot, and they got beat up pretty good as well. And at the end of it, you came out, I thought, smelling like a rose in all this. But you'll probably disagree with that, but I thought you had a pretty good day in court. But basically, it came down to, they used that term competition, that it should be plain as the nose on a person's face, that if you open up the labor market to the spouses of H-1B visa workers, it's going to create competition the same way the H-1B visa worker creates competition. Is that correct?
Well, that's essentially the argument. And here we're going into the distinction of whether the regulation in question allows competition or versus whether they've actually entered the market. Okay. So the precedent in the DC circuit is overwhelming that an agency action that allows competition with you gives rise to standing and to bring your case in the court.
Okay.
So that's, because big business uses this all the time.
Now, weren't you concerned going into this on the question of standing, that it appeared that foreign nationals had standing in the eyes of the court, but the American citizen, the American worker, did not?
Well, standing is always a concern because it's such a mess. I mean, I don't know if to go a little history. I know that most of the audience are probably engineers and tech workers, and they have to appreciate that judges aren't tech workers and engineers of science, and they think differently. Okay, and so the laws, when we talk about laws in the sciences, we talk about well-defined principles that are testable. And standing is not well-defined. The problem, if we go into history, is when you bring a case, okay, throughout traditionally history, you would have to have a cause of action, what they call something like trespass, battery, so that you have to bring some recognized cause of action. Like if your neighbor paints his house purple, okay, it probably devalues your house, but it's unlikely, unless you have some zoning restrictions or historical restrictions, that you have a cause of action to challenge your neighbor's painting his house purple. So that's the first requirement, is you have to have some sort of cause of action. And in this case, challenging regulations, Congress has created a cause of action to challenge regulations that are in excess of DHS authority.
Correct.
But what is historically in cause of action, you had to have some connection to the injury. So like if you were hit by a car, you would generally have a cause of action to sue the person who hit you with a car. But if you're sitting out in your front yard and you see someone hit by a car, your next door neighbor, for example, hit by a car, you don't have a cause of action to bring a case to sue the guy for hitting your neighbor. Okay.
Right.
And that is sort of what standing is. Okay.
Okay. Now in this, go ahead.
I'm going to caveat here. What makes it complicated is that in the 1930s, the Supreme Court created this doctrine of standing, which is a separate hurdle to get into court, above and beyond, in addition to the having the cause of action. And this doctrine was created to protect the New Deal. So when Roosevelt was doing things that were traditionally unconstitutional, the courts, instead of going to support Roosevelt, instead of going contrary to precedent, they invented the standing doctrine and just said, oh, you don't have standing, bring this suit, so they would never decide the merits. Okay. And what has happened is they've created this convoluted mess of standing rules, and then they continually change them because they're such a mess. And so like the engineers out there, it's kind of, if you start developing a system and you start realizing things are overly complicated, you stop and take another approach. The Supreme Court doesn't say, oh, we screwed up. They just kind of try to tweak it and make it more complicated for each situation.
Okay. Now in this case of H-4 EAD, taking it back down, so you were able to demonstrate that H-1B workers had standing in this, correct?
So they had the H-4 spouses, the court scanned them standing. Okay? But in the district
how about the U.S. tech workers? Do they have standing?
So the district court said the U.S. tech workers did not have standing. Okay.
Okay.
So now these workers, the plaintiffs, were all replaced by H-1B workers.
Right. So and you had what, 60 examples of that, correct?
A bunch of examples, and of the people plaintiffs, they're all only 3 of them are actually named, but there are more of them behind the scenes. But I speak to, but they didn't have standing. They didn't have standing, and what we know that they're competitors with the H-4 workers, with the H-1B workers. We know that the rule allows more H-4 workers into their market. Okay? But the district court wanted some kind of showing that they were actually going into the computer market. So the district court's opinion, based on the states, there's no evidence that these workers would actually enter the tech worker market. Now, complicating this even more, I hate to screw this up for your tech workers, is that we provided evidence that these workers were entering the job market, but the district court excluded it for various reasons, which was issue on appeal that did not actually get raised in oral argument. And we had amici business groups appeared, and they provided the court with 2 studies that found the majority of these workers are tech workers, and with the most common occupation being software developer. So we know with absolute utter certainty that not only were these workers allowed into the computer job market, but that's where most of them went.
And I know from anecdotal evidence, speaking with tech workers, that they have walked into third-party agencies, these body shops, and they saw banks of spouses here on H-4s being trained to pass interviews for tech work.
I've heard that going on. I've heard about the fraudulent resumes. I mean, it's a great scam. The computer job market is completely dysfunctional at this point.
Yeah. Now, getting back to what happened last Friday. So you were able to, it was interesting because the DHS guy, the attorneys for DHS, because I guess at the crux of this, DHS created a policy to rescind the H-4 EAD, their authorization to work, correct? But they're not implementing it, correct?
They're not implementing. It's politics going on.
Right. And they tried to say that there's no indication of harm at this point that the H-4 EADs are doing to U.S. workers. But you were able to diffuse that by saying you don't have to specifically demonstrate harm. Competition is enough to indicate harm, correct?
That's the argument. I mean, it said the D.C. Circuit and the Supreme Court repeatedly held that that if you allow increased competition against a party, that they have standing to challenge the action that caused the competition. It's kind of funny because it has been stated so many times, yet we still argue this in court repeatedly. You know, for example, all the judges on the panel had already had written opinions stating that if you allow competition, you cause an injury. Okay, that's rare. I mean, I've never to have every judge you're going for has written an opinion themselves that supports your position. But that illustrates how common this is. I mean, next to being the subject of the regulation, this is the most common way to have standing.
Okay, so it seems so you've been able to demonstrate standing. You've been able to demonstrate that there's competition, and after the arguments, the justices retired. And what's the next step? I guess they'll render an opinion?
Yes, there could be an opinion, and it could come out 3-6 months from now, for all we know.
Okay.
There's no timeline. And then, I mean, there are basically 3 things that can happen. One, they could affirm the decision of the lower court, which would end this case. Then we'd have to file a new case to challenge the regulation.
Okay.
The second, they could say that they're standing, and just say that they're standing, and then remand it to the district court to decide the merits again.
So you go back to the district court, plead your case, saying, we're here, we have standing, now you have to listen to our arguments, correct?
Well, actually, we've already made the argument, so essentially all the district court would have to do is write an opinion, and then we'd have to appeal that. I mean, so it would be just a bunch of paper shuffling, and then and I suspect that's the most likely outcome. And the third is the court could decide the whole case, because the district. But that seems unlikely given what they've said in the signals they've given. But they could put an end to this thing.
Right, because they seem to have really gotten the point that H-4 EAD, the spouses entering the job market, do create competition for the H-1B or the tech workers, the same way the H-1B workers create competition.
Yeah, they seem to have gotten that. Yes.
Great.
And,
Yeah, so I left the courtroom thinking you had, in a way, we can't say you prevailed at this point, but I'd say your arguments were better received than those of DHS and Immigration Voice.
Well, that's what people seem to be telling me, but I don't know if I'm hearing it from biased sources. But on the other hand, there were things said that give you concern.
Mm-hmm.
Okay.
Okay. Which
Like
would
one of the
be?
judges, Judge Griffith was asking, where was the statistical evidence? Okay. Now, the statistical evidence would be great, but would have been unnecessary. And I'm hoping that he'll go back and say, you hope that he'll go back and say, oh, you don't need that. But you could, so there were these little things that you could say would be disconcerting.
Okay.
It looked like the most likely path would be to find standing, but you could see the tortured path that they could do to find a lack of standing.
Yeah, it's funny. Years ago, we had brought a case to a county court. It was on the county court level, and we were refused petitions because what we were fighting was we found out we weren't addressing a county board of supervisors. We were addressing an authority that evening, and it was a stadium taxing authority. And this was one of those government projects and authorities could not be petitioned, so we couldn't get our petitions. And we're in court battling this thing. And at the end, the judge says, well, you're saying that the vast majority of people in this county don't want this stadium tax. Well, yes. I mean, look at the newspapers, look at this. And he goes, well, show me your petitions. We're like, well, we don't have the petitions because you wouldn't give us the petitions. And he threw it out as a frivolous lawsuit. So, yeah.
Catch-22s in the law. Like
Yep.
that.
Mm-hmm. Mm-hmm. So we'll know, like you said, it could be 3 to 6 months before we hear from them, huh?
Yeah. And instead, if they dismiss the case, then if they affirm the dismissal, then we have to start over with another group. Which case it would be several years. If they decide the merits, it's over now. If they remanded the district court, it's 6 months plus the time for the district court to do another opinion, then another appeal. So you're talking another 2 or 3 years.
Now, in all this time, do you think there's any chance that DHS might come to their senses and rescind the H-4 EAD?
Well, DHS is playing a little game here. This is one people have to understand. President Trump's greatest failing has been poor staffing. Okay?
Right. We saw that with Nielsen early on.
Yep, Nielsen out there. We have the whole crew. Trump says one thing, but the bureaucracy in DHS and even the leadership in many cases in DHS do not support his agenda. Okay, so one of the factors here is DHS does not want a decision on the merits in this case. Okay, the problem is that the DHS has adopted this position that they have unlimited authority to allow alien employment through regulation. Right? They push that. DACA, H-4, OPT, international entrepreneurial. There are other regulations in which they are granting alien employment without authorization for Congress because they say Congress has told them we can do anything we want. So they don't want a decision on that. So they're desperately trying to avoid this case getting to a decision. So if the court does grant standing, I think, or even now that they've decided to hear the case, I think there's going to be impetus in DHS to move a rescinding regulation along in order to avoid getting a decision on this question. Okay, because the bureaucracy in DHS does not want to rescind this regulation. Okay, they're only doing it because they're forced to, which is why this thing hasn't moved.
Mm-hmm. And ourselves, we look at our FOIA requests that we put into USCIS, into Department of Labor. It's almost like they're slow walking everything.
Yeah. I said Trump, it's sad, but Trump did not put people in place that are supporting his agenda. So things haven't happened. Now, look in the case. I've been litigating the same question here, whether of DHS authority, ever since I got out of law school. Right? And DHS is able to drag these cases out for decades. We're now in the second decade of this. We're still litigating issues brought from the Bush administration.
My gosh.
Programs created in the Bush administration. So the courts. You would think at some point they'd be ready to jump in and put an end to this nonsense, but instead they've been allowing it to go on and on and on.
Wow. So I guess we'll just have to wait and see how this goes. Hope maybe that Trump will make some decent appointments going further. I personally was not aware of how much control DHS and other agencies seem to have, the control they can exercise over who's allowed to work in the U.S. and who isn't. It just almost seems to me that Congress is not doing its duty by allowing agencies to have that level of control.
Well, that's one of the great debates of democracy. Congress has allowed this creation of this administrative state, that more law comes out of the bureaucracy than from Congress. And one of the problems we have is that Congress has taken on itself to regulate every aspect of American life. They authorize regulations on toilet, refrigerators, light bulbs, and Congress can't possibly create this, cannot manage these things. And if you went back 50 years, or even if we can go back to the start of the New Deal, Congress had dealt with fewer things. And so they were able to deal with those things with competence. Now Congress really can't do anything. They don't have a mastery of anyone. And one of the issues we talk about is this so-called Fairness for High-Skilled Immigrants Act that we just going out there. If Congress had any basic competence in immigration, this would be dead. But they don't have anyone really in Congress who knows the system well enough to say, if we enact this, it's going to create a train wreck in the system. And
a lot of people predicted this back in 1990, what would happen if they were to enact legislation or if they were authorized these kind of employment visas. We knew what would happen, particularly the dual intent nature of the H-1B. It should be an employment only visa. This is why there's a backlog. We allow people to come here for quote unquote employment purposes, and then we allow them to apply for green cards. It becomes an immigration purpose.
That's it. That's the fundamental problem here. And you don't see anyone in Congress talking about that. Is that, maybe we need to revise the dual intent. Instead, Congress has doubled down and now tripling down on mistakes they've made in 2000.
We just look at S-386, and that is a prime example of this level of incompetence, where what they're doing is attempting to placate a lobbying group, a group that's supported by entities like the Business Roundtable, the Fortune 100 companies here in the United States, Silicon Valley, the body shops that make billions off of moving people from India to the United States. And that's who they seem to be listening to. They're not listening to the citizens, to the workers. And tragically, John, I've always said many of these problems that we're facing require a legislative solution. But as you just pointed out, it's almost as if Congress's hands are tied, or they simply aren't competent enough to engage in that process.
Yeah, one of the things that I guess the general public doesn't even realize is that Congress doesn't even write the bills anymore. Now they're written by the lobbyists, and the bills just get longer and longer and more convoluted, so that only insiders know them and can navigate them. That, I mean, immigration bills used to be relatively short and easy to understand, and now they're hundreds of pages, in cases thousands of pages long. And also, I'd throw another bad factor is the media.
Right.
That now we have, I mean, a media that's what we call the elite media, is controlled by a handful of companies who are
Right.
interested in this.
It's an arm of the corporatocracy. And in this instance, I spent an hour on the phone a year ago with a reporter for the New York Times, whose name I will not mention, but she covers immigration issues. And after an hour of me telling her that the harm that has been done to tech workers and other workers due to employment visa abuse, she goes to me, she goes, "Kevin, what about the woman in the golden cage?" I'm like, "What?" "The H-4, the spouses, they're here and they can't work." And I'm like, "Lady, that should be testament that we have a system that's failing everyone. If the spouse has to work to, if we're bringing people here on employment visas and now we're saying the spouse has to work for them to make ends meet, don't you think there's a problem with the way wages are? And don't you think supply and demand is a factor in that? The fact that wages have remained stagnant really since the 70s, particularly, and they've deflated in the area of tech work and some of our most productive workers. Oh my gosh. But this is what you get. She gives me this metaphor for people to hang their hats on. Not the couple that is struggling, working 3 to 4 jobs to make ends meet, but, the woman in the golden cage. But what about the employee here who's been fired? And where would she suggest they immigrate to find a better life, to be in at least the golden cage?
Yeah, the American media is completely useless on this issue by and large. And even on this Fairness for High Skilled Immigrants Act, I've spoken to many reporters on it. This is probably the most significant immigration bill of the past 50 years, and there's no coverage. So here you have merely the most significant immigration bill of the past 50 years, and I've only seen one newspaper article, the one in the Miami Herald, that actually described what the bill did.
Yes. And essentially they said, look, guys,
it's all in superficial return. That it's oh, well, now no one, if you do that, then no Hispanics will be able to get green cards, employment-based green cards, and no one seems, and there seems to be no concern about that. And I assume that that's because of the corporate control of the media these days.
Yep, absolutely. Well, John, our priorities, U.S. tech workers, our priorities are going forward, working to educate tech workers and other activists out there to ensure that when the Senate returns from their October recess, that this bill doesn't come to the floor. And if we can do that, I think, there's a victory in that, because I was amazed at the turnout. I look at and it really goes back for us a year. We've been educating workers for a year and training activists, teaching activists to lead other activists for over a year. And it was amazing the turnout that we had on the Hill. People came out. I mean, I think there was a point where they thought maybe a riot would break out, I was told. So we've been successful there. And I think going forward in the midterm, what we need to do is come up with ideas for reform that will reform the employment visa system in total so that it works for both the U.S. citizen, whether they're native born or naturalized, and the new arrival, so that everyone is benefiting.
Yeah, well, you're going to have the big business and immigration lawyers against you on that.
Yeah, we already do. I know several activists that have been doxxed by members of Immigration Voice. It's pretty brutal what they do to people that stick their heads up. Interestingly enough, I was in the Bay Area last week speaking with tech workers. And what they told me was, they look, Kevin, if I stick my head up, I'll get blacklisted. If I get blacklisted, I'll get fired. If I'm fired, I'll never work in Silicon Valley again. I mean, we've gone back to the late 1800s, early 1900s in terms of labor relations.
Yeah, well, we have in tech workers have no professional organizations really to speak of. The unions have basically evaporated in the commercial market, in the non-government market, and so there's no great force to fight back. And so, from the tech workers, it's almost the tech worker motto is almost, "Thank you, sir. May I have another?"
Right.
And it's because they have not stood up to this as they're seeing declining wages or flat wages for decades. Meanwhile, at the very top, you get billions of dollars.
Yeah, enormous spreads when you look at the profits.
Yeah, there's great income inequity, and this is one of the reasons for it. And the big business wants cheap foreign workers bound to the employer for years. Immigration lawyers want the system to be as complicated as possible, so you have to use a lawyer for their services. And they would prefer to have big businesses as the clients than individual aliens seeking to immigrate.
Yep.
So that's the force is against us.
It's a destructive cycle for the workers of this country. And, frankly, we have to grow this movement now. We got to look beyond tech workers, because all white collar workers, all knowledge workers are impacted by these employment visa programs. It's not just STEM, science, technology, engineering, math. It's accountants. It's back office support workers. It's all kinds of knowledge work that's, in addition to having their lunch eaten by AI. But one of the myths that I've found out there is people are trying to say, well, it's not globalization, it's not the movement of people, it's really AI. Well, every time we've had a technological revolution, we've been able to employ more people and drive productivity, effectiveness, and efficiency. And this is the first time we have it. It's because there is, I believe, this war on our productive class, where they don't want to pay them a decent living wage, they don't want to pay benefits, and they don't want to pay pensions.
There was a article that came out yesterday in some smaller publication, which they were referring to H-1B workers as affordable tech workers.
Oh my God.
It's all about the money, folks. It's all about the money, and H-1B is all about transferring the middle class wealth, the limited wealth of the middle class, into the upper class, the Zuckerbergs and Bill Gates of the world.
Yeah, that's a great tragedy. Well, I'm gonna have to finish our conversation there, John. Is there anything I've missed that you'd like to pass on to the audience?
Well, the big thing is we've got to get organized. You need to be telling your friends about this. You need to get them involved in groups. Otherwise, things are just going to continue the way they're going. And as I tell people all the time, if the public knew what I've learned about our government, the revolution would have happened already.
Well, on that note, John, I'm going to end with saying to our audience, if you like this video, give us a thumbs up. Hey, and if you didn't like it, give it a thumbs down. It still helps with the algorithm in terms of getting us out there. And if you haven't done so, please hit the subscribe button to our YouTube page. That way you can be informed anytime that we put something new up there. And also, go to the US Tech Workers page. Go to the Support Us page and donate. Your money allows us to continue our advocacy, continue to train activists, continue to educate the public, continue to educate members of the legislature on the plight of tech workers, knowledge workers, and employment visa abuse. Well, on that, John, thanks for joining us. Everyone, thank you for being with us and have a great day.